The following short video is presented by the Northern Community Legal Centre and the Moonee Valley Community Legal Service. It has been designed to introduce the Family Law Act and the rights and responsibility of those engaged in family dispute resolution. The Family Law Act, which has been in existence since 1975, gives directions on the approach that must be taken with disputes involving families. There are a lot of myths within the community about the Family Law Act, particularly when there are disputes involving children. There are too many to mention in this short video, but here are a few common ones. Myth 1. Parents have the rights. Children have rights, parents have responsibilities. Myth 2. Payment of child support means I have the right to see my child. You are responsible as a parent to pay child support regardless of whether you spend time with your child or not. Myth 3. There is an automatic entitlement to an equal time arrangement. The law states that when it comes to time arrangements, the best interests of the children must always be considered, and they must be workable and practical. Myth 4. Men and women aren't treated equally. The Family Law Act refers to the parent, not a mum or a dad. The aim of the Act is to ensure that any actions, agreements or decisions are in the best interests of the children. The Act also states that the children have a right to have a meaningful relationship with both parents and significant others, unless they are at risk of family abuse, neglect, harm or family violence. A lot of people ask the question, I've just split up with my partner and I want to know what my rights are in relation to my children. Parents don't have rights. Children have the right to have a meaningful relationship with both of their parents and to be protected from harm. Parents have the responsibility to protect their children and to look after them financially and emotionally, and to facilitate a positive relationship with the other parent. And the greatest priority is to always ensure that the children are safe. So, under the Family Law Act, there is a presumption that the parents will have equal shared parental responsibility, unless there is family violence, abuse, or another reason that is found that it's not in the best interest of the child. Most parents agree to share parental responsibility for their children. This means that both parents are involved in making long-term decisions on their children's future, on matters such as name changes, relocation, religion, education, and their health. The equal shared parental responsibility presumption does not apply to grandparents, step-parents, or significant others.
There's nothing in the Family Law Act that says once you split up, you have to have a formal agreement. If you are able to come up with an informal arrangement that works, then that's great. However, some informal arrangements don't always work, and that's when other alternatives under the Family Law Act are often sought. These can include parenting plans, consent orders, and court orders. At the Family Relationship Centre, if parents are able to agree with respect to arrangements for the children, then most often they choose to document that by way of a parenting plan. One of the major advantages of a parenting plan is that they're flexible and they can be easily updated, which works really well for children and their growing needs. So you can try it for a period of time, and if you need to, you can easily agree to update it or amend it. However, there are no legal consequences if a parenting plan is not followed. Parenting plans can be used as evidence later on in court, but they're not formally binding. There are also consent orders. If you'd like to have your agreement made formal and binding, it is possible to have the parenting plan made into consent orders, but both parties have to agree to this. This will require you to make an application to the court and pay a fee. Where disagreement occurs, you can also make an application to the court and have a judge decide your case. This is known as a court order. Bear in mind, court can be a very stressful process, and it's expensive unless you're eligible for Victoria Legal Aid funding. When coming to a decision with respect to children's arrangements, judges consider a number of different factors. Under the Family Law Act, judges need to decide whether the arrangements for the children are workable or practicable, or to divide the time in a way that's best for the children. The Family Law Act lists the following factors that a judge must consider: family violence orders and safety concerns. The safety of the children must always come first. Arrangements for the children being workable and practicable. the work schedules of the parents and how this may impact on their time or care spent with the children, children's schedules, and in particular which parent can cater to their child best, the child's wishes. These are taken into account depending on the age and maturity of the child, how well you as parents get on with each other. Family violence or conflict is not found to be in the child's best interests. The length of time and frequency since you last saw the child. The relationship with other family members, including step-parents and grandparents, is also taken into account. And any costs associated with the visits. For example, the costs of any supervised contact centres. Court orders are enforceable. However, those seeking to go to court for a judge-made order need to consider the following. The local police won't get involved unless there is a safety or family violence issue. If an order has been breached, you need to make an application to the court to enforce it. If the matter is urgent, for example, someone's unreasonably withheld a child, then you can immediately take it back to court. Otherwise, you'll need to attend mediation. However, if the matter is not urgent and 12 months has lapsed, then you'll need to go back to mediation before you can go back to court.
For many people, the decisions that need to be made can be overwhelming. To help you, there are a number of support services available. During the family dispute resolution process, your mediator can assist you in getting the support that you need. You can also access free legal advice from the Northern Community Legal Centre or the Moonee Valley Legal Service. The majority of people that we assist are parents, but we also assist grandparents and step-parents. For those of you that can't access our services, there is a legal service available in your local government area as well.